Okay, so welcome everyone. My name is Alice Shakina, and we will be talking today about inheritance, transferring family wealth. So I just wanted to welcome you all here today, and we are going to be doing quick introductions about who we each are, and then we will move into the next portion, which is we'll be talking about why we're here, like what each of us would like you to gain today out of today's talk. So Darcy, if you want to begin introducing yourself.
Sure. My name's Darcy Elman. I am with Compass Real Estate. I am a real estate agent that specializes in helping families, individuals, couples with residential real estate. And my passion is helping people build their wealth through purchasing and selling, helping people sell properties. I specifically sell in San Francisco. I specifically focus in Marin. Those are the two areas that I focus with my clients. And I do some residential commercial as well.
And I'm Alice Shakina. I am a mediator. I mediate several types of things. For instance, divorces. I also do conservatorships, personal injury, a lot of housing. And I also do a lot of family conflict. So that will come into play in today's conversation, where I basically am helping people get through the conflict and get to some kind of resolution. Jay?
Good afternoon, everybody. I'm Jay O'Neill. I'm a trust and estates attorney at the law offices of James O'Neill, and I focus my practice on estate planning and estate administration. And what that means is I help people prepare for the inevitable, and I also help manage what happens afterwards, whether they have a plan or not. That could be probate or that could be trust administration. And a lot of what I do touches the same basis as Alice and Darcy as far as real estate and family conflict and housing and conservatorships and issues like that. So my goal is to help people either plan in advance to make sure that there's as smooth a transition as possible when that transfer is needed, or where there wasn't planning, trying to find out how to take the burden off of my client's shoulders as much as I can to help them get through that period so they can focus on caring for their loved ones and grieving and all the things that go along when we lose somebody we love.
Yeah, I would say one thing about my goal when I started to think about what happens, not what I mean, when I started to get calls about inherited properties, the two things that came up for me were it is so sad that the kids didn't know anything about their parents' estate, and some people had multiple properties. And the other is often I get calls just for the assessment. What do you think this house is worth? But there is so much more that goes in to handling an inherited property that I realized that if I could educate everyone on this call and then others who listen to this, they can see the depth and the importance of having these conversations with their family and also taking care of their own properties so that if anything should happen, you know, to them and they would have their plan intact. And hopefully you guys will understand why it's so important to put your properties in a trust. And I'm sure you know mostly why that's important, but once we unravel what happens when things aren't in a trust, it's going to be a little illuminating how important it is to pass that information on to your family and also to your clients.
And from my perspective, I just wanted to talk about how mediation can come into play. Frequently, people only think of mediation as something that you do when you're in the middle of litigation. It's not something that is viewed as a preventative process. It's not something that's viewed as a process that just regular family members can engage in if they're having trouble speaking about things, because either they have very opposing viewpoints or maybe there's a long history of conflict and they just don't want to deal with each other. So I'll be talking today about how you can use this process even when there is no litigation, but when you're just trying to figure something out.
Perfect.
Okay, so one of the first things we need to understand when we're talking about family wealth transfer at any stage of the spectrum, as it were, is who are the stakeholders. really who is in the room with us, who has a vested interest, and what are those interests. So I frequently, when I do an estate plan, I'll get a telephone call or a married couple will come into my office. And when they're thinking about who the stakeholders are, they're thinking about themselves a little bit, but really they're thinking about their children or their grandchildren, right? And that's really who they see the stakeholders as. They're really thinking about that most important thing in their life, which is they want their very final act, the very last thing they do, to be to make sure they've taken care of the people that they love, right? So even after they've passed, the last act they have is an estate plan. And so that's who they think of as the stakeholders. Now, definitely the clients are stakeholders. They frequently don't even think of the question of what happens if I become incapacitated, right? There's either not the thought of what happens with that, or there's an assumption underlining that what happens. They assume maybe a family member can step in. So they're focused on the transfer issue, what happens when I die, and that's really important, but that's not the first thing we need to think of. They are stakeholders in their own plan because the decisions they make will impact them. Their children plainly are stakeholders if they have children, whether they're natural born or adopted or people that they've treated like children their entire lives, that they are, fundamentally responsible for the care, and they want to make sure that they help them out. And the children, of course, will have their own agendas when they come into the equation, right? Because the parents, when they think of their children, are thinking like almost like Christmas or a holiday where you're giving a gift to somebody, right? And they see this opportunity to transfer this wealth as a gift. The children may have their own problems. And I always think of the Harry Potter scene, the very first movie, where the Dursley's little boy is counting the number of birthday gifts he's gotten, and it's not the exact same or more than he got the previous year. And so he's angry, not happy that he's received 30 odd gifts, but he's angry. And children are going to have their own issues, right? So if they're grown children, maybe they're struggling financially. Maybe they have issues providing for their children. Maybe there are dependency issues in there, addiction issues going on. And they have spouses to contend with, right, who have their own interests. So when we get to extended family, right, we have brothers and sisters who may feel a sense of ownership in the process or over some of the assets, or maybe they feel like they have the best judgment. And this comes in so many shapes and forms. I have a probate right now where the lover is ending up with half of a house sort of unexpectedly. So we have under extended family, we have these brothers and sisters and cousins and nieces and step parents and just this whole array of people who have an interest in a plan. And then there's the group that no one ever thinks about, which is everybody else, the government, because people don't even know really what the government's interest is, right? The IRS wants their taxes. The Franchise Tax Board wants their taxes. The DMV has concerns over the automobiles. The Department of Healthcare Services has interest in claiming Medi-Cal money expended. And then there are the corporate institutions like insurance companies and mortgage providers and banks and landlords and tenants and credit card companies. There's this whole host of people that are really all of these people are at the table when someone is setting up their plan. It's just that we're not really thinking about it, or frequently people aren't thinking about it, either when they make a plan or when they don't make a plan. So it's really important when we're talking about family dynamics is to understand the agendas of everybody who's coming into the room, or who, even if they're not in the room, is present by interest in the room when we're making a plan, or after the fact when we're cleaning up under a plan. Because frequently people will make assumptions. If there is no estate plan and there's a piece of real estate to be inherited, they'll make assumptions about what is supposed to happen with that. And they'll be simplified assumptions that their taxing authorities have interest, or that the Department of Healthcare Services may come and claim hundreds of thousands of dollars out of that estate. Or the tenants have their own agendas, and in a rent controlled jurisdiction, that's a pretty important party at the table, even if you don't know who they are. So when we're looking at stakeholders, it's important to understand stakeholders, and it's important to understand agendas, because at some point the stakeholders and the agendas will have to be reconciled. So do we want to move on to the next slide?
Yes. So there's a lot that happens. I can't talk about estate planning, but from my side, one of the two, everything boils down to when someone dies, do they have a will? And if they have a will, do they have property? And if they have property and it's just a will, it will go to probate. And if you have a trust, meaning all the property is held within a trust, then the government cannot touch that property. That's not to say that there are not tax implications when you go to sell, but that the decisions that you make around real estate and property, you're not waiting on the government to verify that who owned it and that they did die. So a trust is, yeah, here's the property. You can move forward once you decide what's the family decides what to do. I want to talk a little bit, just really briefly, about taxes and just give you a little overview. And we'll take, for an example, a single family home, let's say in the Castro area of San Francisco. The family died. There's a few kids, and the house, there is a mortgage on this house, and the kids are trying to decide, do they sell, what to do with the house. Well, the first thing in my eyes when I get a call, what I would recommend is to actually make an overview assessment of where that property sits in terms of what's the value of the property. I would educate all of you to understand that the capital gains does not apply because you guys haven't, the family members have not lived in that property. So if they decide to move in, then capital gains, they would actually be able to benefit from capital gains. They would have to live there for 2 years. But if the family members decide to sell, that they will be taxed on the original sale price of the deceased. And they will not be taxed on, really important, any appreciation from the moment that closed with that original sale of the deceased. All that appreciation will not be taxed unless you put that house on the market. And let's say that house is on the market, the comps say, you could definitely get $1.7 million for this single family home in the Castro. But let's say it sold for $2 million because someone walked in and they're like, this location, oh my God, I want it. I've got cash, $2 million. You will be taxed on the $300,000 because it went over and above the market rate and the original price that the deceased bought it for. That's just fast, furious. That's what it is. But backing up before you put it on the market, is there a mortgage? Because you may have inherited that property and now you have to take care of that mortgage. Are there liens on the property? Is there debt that comes with the inheritance? The people who are the family members that inherited that, family members or loved ones or cousins, or everyone will be responsible. You see how emotionally difficult this is now becoming and entangled. Every one of those people, every one of the family members and not family members will be responsible for the debt. So handling a home before you put it on the market, when I say understanding the ROI, the return on the investment, right? Even though it's not really investment, you're just getting this, you still have to look at what money is going out once I sell that. And let's say a family member, and this is where mediation is going to come in, says, wait a minute, I don't even have a place to live. Mom always told me I could move in. What happens in that moment? You have all these different people's agendas. So why I'm saying this is that I'm not even talking about the pitfalls of if a property is underwater, but even before that money can be divided, all those debts have to be satisfied. And that's a really big thing. And then the other thing that the inherited person must do, or people must do, is they must let the IRS know and file a tax return for the deceased. And I don't understand this, and maybe Jay can help me out on this. For the deceased to let the IRS know they died and this home is going up for sale if that's the choice, because the how that house is going to be taxed, as if I get this correctly, is that the IRS, you file for it and the IRS sends that final amount on what will be owed. Is that correct, Jay?
Well, so when we look at how the taxing authorities play into an estate, to answer the first part of that question, what happens when someone dies? They usually don't die on December 31st at 11:59 p.m., right? So there's a portion of the year for that tax year where they are still an individual filing an individual tax return, right? And so we file that final tax return. When we say we arrange a CPA, but they file a final tax return for the individual. So the IRS knows that was the taxable income and so forth for that individual's life. But after they die, we have to get a separate tax ID for their estate. So they get a number like a social called an EIN that's assigned to their state. And their estate will be pay taxes depending on income over the course of the administration. So if someone dies on June 30th of 2020, we're going to file a 6-month tax return for 2020 for the individual, and a 6-month, possibly depending on how we decide to elect the calendaring, 6-month return for the estate. Now the estate, important thing to know here, and this comes into play with the question of the house and rent, is the estate reaches, like a trust for instance, reaches the highest marginal tax bracket very, very quickly. At about $14,000, you're hitting the highest tax rate. So issues of income taxation during the course of the administration is a big deal because it can wipe out a substantial amount of that income. Moreover, when we're talking about a house, frequently there's been a first spouse to die and a second spouse to die, and maybe a period of time that the house has been held before it's sold. And I can say from my practice in probate, I have had probates roll in 10 or 12 years after the person died. So even if they get a full step up in basis for capital gains tax at the date of death of that parent, back in 98 or whenever it might have been, the appreciation on their date of death till when it's sold will be taxed. And you can consult with the tax preparer, but you can assume it will be at least a 15% taxation if there's a transfer of that title long after substantial appreciation. And that will substantially reduce the value of the estate that's going to the children. So you can imagine in 2008, we had this crash. Property values dropped pretty substantially. Now, let's say someone died in 2010 with one of those houses that maybe was worth 400,000 then in Oakland, and is now worth 1.3, and they don't get around to dealing with it in 2020. You've got a substantial tax burden there. So taxes are really important to plan for either beforehand, and there are ways to plan for taxes, for capital gains taxes, which I think Darcy is focusing on, and property taxes, right? Because there's always more than one form of tax available to us. There's property tax, there's a rental, there's income tax. If there's a sale, there's capital gains tax. And there's a whole slew of property tax regimens that really matter. So if you leave a house to children, a primary residence to children, they can inherit at the same property tax basis. That's the big deal, right? 10 years of paying an adjusted property tax basis of $15,000 is a lot, right? $150,000 out the window. So when you're deciding how to leave assets, it might make more sense to leave it to the kids who won't be reassessed than to a brother or sister who are not exempt from reassessment and would be reassessed. So you do want to be aware either before the fact when you're planning, hopefully, of property tax, capital gains tax, and income tax implications of the asset or the assets when making these transfers, because it'll impact who gets what. And to another point Darcy made there, she's absolutely right. There is always a family member who can afford Bay Area rents who wants to live in the house rent free. And what does that mean if there are 3 siblings and one is living rent free and the other has a house, maybe in Berkeley, and the third one's living in New York? Well, what it means is that person who's living there rent free is getting that 1/3 interest in the house, right? They have that equitable interest in that, and they're getting free rent. So if they live there for 10 years, and that rent is $5,000 a month, that's $600,000 of additional benefit they got out of the estate, while the other two family members who were entitled to that property had to keep helping paying the mortgage and paying the insurance and paying the property taxes and didn't get a benefit. So frequently this comes to questions of fairness, right? How do we define fair? And I can guarantee you that all of those three different siblings are going to have different definitions of fair. One sibling is going to say, well, 1/3 is fair. The one in New York is going to say 1/3 is fair. The child who took care of the ailing parent is going to say, no, it should be proportional to the effort you put into taking care of mom and dad. And then the question of what's fair for who pays these taxes and expenses is going to be fought over too. Well, you're living in the house, you pay the taxes and the mortgage. Well, if I pay the mortgage, I get a bigger equitable interest. So you see how it all can spiral together without a plan. And it mostly does focus. The important thing here is around real estate in the Bay Area. The vast majority of estate issues, whether it's litigation or planning or administration, have to do with the real estate, because that is the asset that has substantially appreciated recently. So these are things we want to take into consideration. Hopefully that answered your question, Darcy. Maybe plus
Yeah,
a
I
little.
mean, one thing I want to say before I go to the next slide, because it's going to lead into mediation. And I think, I don't know, I'm always really interested in problem solving when it comes to, emotional entanglements. But I will say one thing, if one of the family members chooses to move into the house, and they stay in that house for 2 years, they then are, they can use the capital gains if they go to sell in 2 years. So that also needs to be taken into consideration, because maybe family members like, well, we need that $250,000 write-off because after everyone gets paid, I mean, we could use that. So it's there are pros and cons on each level is what I'm trying to say. I think one of the most important aspects is to understand that the market is always fluctuating, and that the amount that house in the Castro was worth today may change dramatically in 2 years. And if, one of the siblings really needs to live in it 2 years, it actually could go down in value. Like, we don't know where the market's going to go. We can say, well, we live in a little bubble here, but in the end of the day, we don't know. And not only that, but sometimes family members choose not to, if the house has a lot of deferred maintenance, and if it's structurally not that sound, it could cost quite a bit of money just to get it ready to go to market. So sometimes making the choice to sell it as is, even though it's quite a bit less, it just is what it is. No one wants to put the money in. And but anyway, so
Well,
it's complicated.
and Darcy, just to your point about the family member who moves in and starts paying things, in my experience in the probate and trust administration world, an occupied house is a little harder to sell for a little less of a value. And what happens when that family member who moved in and maybe said, I'll take care of upkeeping the property, have they created a defense in essence that they're now a tenant and protected under the rent control and eviction control laws that have historically been in Berkeley, Oakland, and San Francisco, but have really in a lot of ways and shape now covered a lot of California under more recently enacted laws. So there are pitfalls, the traps for the unwary that a lot of us will sit there and think, well, sure, Bill's having a hard time, I'll let him move into the place till he gets back on his feet. I don't, family takes care of family. And then 3 years later, they're fighting an eviction lawsuit, trying to get him out of that house just so that they can sell it.
Yeah. Yep.
Okay, so yeah, the benefits of mediation. So I just wanted to talk a little bit about, who can move into mediation. So the biggest caveat is that everyone has to agree to mediate. It's Most of the time, it is a voluntary process, right? The only time it's not is if a judge orders it, if you're in litigation. So mediation can be with two parties. It can also be with multiple parties, which happens to be the case whenever you have multiple parties inheriting some kind of real estate. It's usually siblings, and there's like 3, 4, 5 or so people, and everyone, as Jay mentioned, has a different idea of what they would like to do and different needs. So this would be a great example of where they could call a mediator, agree to mediate, and move into mediation. It does not have to be associated with any sort of a court case. It doesn't have to have anything filed. Literally, it can happen maybe even before they inherit it. You know, a lot of times families know prior to the passing of someone that once their parents pass, that they're going to be inheriting things. And it's actually probably a pretty smart move to try to have a mediation amongst all of the siblings before that inheritance occurs, so that you're poised and in a good place to figure out business-wise, tax-wise, what will happen when your parents pass and then you do inherit it. However, let's say that they suddenly die, you weren't expecting it, and then you do inherit it, and you have a host of issues because people are just not in agreement. Really good chance to mediate. Okay. What it does is it brings people together to have a conversation, and also it helps them problem solve, so that, like you guys mentioned, well, what happens if someone has no place to live and this is their only place to live? And then how do we pay each other out? What do we do with the other 2/3 if they're only owning 1/3? These are the types of issues that we discuss in mediation. We talk about fair ways. And as Jay mentioned, people might think of the definition of fair in a different manner. But what we do in mediation is we try to come to a place where everyone feels like the end result is fair for everyone, not just fair for themselves or just fair for that one brother who doesn't have any place to live. It's literally trying to come to an understanding with everyone. The settlement agreements can be binding. If you just want, if you all agree to make it binding, then you just say that, hey, we're going to write in here that this is a binding mediation contract, and then you sign. And it's also much, much cheaper to mediate than to litigate. We're going to go into the costs of that. But yes, it's definitely cheaper to mediate, and you can get it done in much less time. If you litigate it, or if things go through probate, it can take years.
Alice, can I just jump in really quick
Sure.
on mediation for a second? So, you know, the lawyer's perspective on mediation, the easiest way I find to explain to clients why they want to mediate is when you are mediating a dispute, you have control, at least in some part, on the outcome, right? So if I sit down and I have a dispute with my brother about how we're going to handle my mother's estate, we can work out a solution together. Now, it may not be the one I wanted the most. I get everything, right? That's the reasonable solution. I get everything. That's what I'm thinking. But I have some control on the outcome. It's like a negotiation. Once you give up on mediation and kick it over to the court, you're asking someone who doesn't know you, the judge, or maybe doesn't even want to be there, the jury, each of whom who has their own agenda from their own personal experience with issues like this, to decide what's going to happen to you. So fundamentally, the benefit of mediation from my perspective is getting to the result you can guarantee, as opposed to the one that's imposed on you. One of the other things I really want to point out about mediation, from my experience both personally and as an attorney representing clients, is frequently when parties in a dispute come to a table, they're locked into two viewpoints on how we solve this. I get what I want, or I get what I want. And it's really easy to get locked up, and lawyers are guilty of this too, where we see a problem and we only identify 3 tools for solving that problem. The benefit of mediation in a case like that is you get a third-party perspective, someone whose whole job is to resolve problems, who has an immense bag of resources for solving problems just like yours. Unconventional, or at least unconventional from your perspective walking into that room or that Zoom call, but satisfying. I can tell you I've been in numerous mediations where I had no idea what the final outcome was going to look like. And I certainly was pleased with where we got to. It left each party feeling like they got what they really cared about at the end of the day. It was just through a path that none of us had seen before that moment. So I think it's really important in contrast to arbitration, where there's a third party deciding, or court, where there's a third party deciding to keep control for you and your family. And it doesn't have to be one meeting, right? It can be a 3-part mediation. Maybe you solve one issue in the first mediation and keep going on to the other issues at later mediations, but find agreements on the areas you can agree on, and at least narrow the scope of what you disagree on, and only putting in front of a judge as much as you absolutely have to.
And I also wanted to add too that mediation can happen anytime, meaning you can maybe mediate prior to inheriting. And let's say that you don't agree and you just let it go, right? Then later after you inherit, then you can try mediation again. Let's say it doesn't work then and you move into litigation. At any point during the entire litigation, from when it was filed all the way till right before it goes to trial, you can always opt back into mediation. So you can do it multiple times if it doesn't settle.
And frequently, the benefit of an early mediation there is you at least get some insight to what the other parties are thinking, right? You might have a story in your head that you've told yourself about what they're thinking, but an early mediation helps you really understand how they're attacking the problem.
And now here we talk a little bit about the costs of the different things. So cost of mediation can run anywhere depending on how many times you do it, how long, and that sort of thing. But, sort of a general idea, under 10 grand. If you're going to do a buyout, then it could be 25 plus grand. Then if you want to go to trial, you're going to start talking about 6-figure numbers. So you can see the vast difference between what you would pay out if you're trying mediation versus if you just say, you know what, let's let a judge decide, right? Or a jury. And as Jay mentioned, like, they don't want to be there, and they also don't want to be the ones making the decision for you. This is a very personal matter. And ideally they would like you to work it out because you know yourselves the best and you know what would be the best resolution. And so leaving this decision to a judge doesn't mean the judge relishes in making these calls, right? They'd much rather you take matters into your own hands and come up with an agreement that works for you, as opposed to throwing it to the judge. And so you can see the cost becomes very, very prohibitive. And, you may lose the entire value of what you're inheriting if you go all the way through trial.
So that's right. On the trial side, I've done estate litigation. I don't do as much of it anymore, but people, when they think about divorce, they think the lawyers always win. That's the common refrain, right? Because every time wife sends an email, husband's lawyer reads it, writes one back, and it goes back and forth. Now imagine if you've got 40 years of grievance built up with your siblings and your parents and your cousins and whoever else is at that table, and there's 7 of you, and a lawyer sends out an email. Now all 7 of the attorneys are either writing or reading those emails and responding to it, and they're billing against the value of that estate, and that's their security. So that means, if I charge 1/10 of my 1/10 of 1 hour writing an email at $45, and every other attorney out there does, well, you can multiply 45 times 7, you've got an idea of how much that 10 minutes just cost the estate. And there are going to be many, many, many of those emails. So when it says 100,000 plus, when I've counseled clients in the past about mediating versus going to litigation, because early on everyone wants to let the judge decide it, I tell them this could cost $250,000 just to you, not to mention the other members. So if you're looking at 1% of the cost to mediate to the solution versus 10, 100 times that amount to get to a solution, the return on investment of trying that route is plain and clear.
Yeah, I wanted to chime in too. And I'm really saying this because one of the things that we're all talking about is having all the information and tools available to find a resolution, to come to a resolution. And I think that if you ask a good realtor to give you a list of everything that estate is going to, all that person can imagine or estimate that estate has, the debts of that estate, and also what that asset will bring you, and with the commissions and with the closing costs, because you have to take that into consideration, and you bring all those numbers into mediation. I don't know if anyone ever does this, but if you were to ask me, I would say you guys need to mediate. Let me give you all the numbers and all the possibilities and bring that to the mediation table. because everyone has an agenda, but the reality is it's a building and that building has a value, and you work with a professional to find out what that value is and what those costs are going to be. That's going to be like ground the whole conversation. So I just thought I'd say that because I think there's between the three of us, I mean, you could get, I mean, you could call any one of us and for your clients and make really great headway before you go into litigation.
And I think that's an important point is, the emotional agenda versus the financial agenda often get confused.
Yeah.
At the end of the day, we all care about the financial agenda. At the beginning of the day, we're all thinking about the emotional agenda, right? The anger in the family. Um, but I can tell you, I've never had a client say, I was so glad I spent that money getting back at my brother, right? Never had. And I tell clients this up front, that you may want emotional validation today, but you want financial validation at the end of the estate. There's no two ways about that. And the only real way to do that is to take an approach from making business-like decisions where you have spreadsheets of scenarios. What happens if we do this? What happens if we do that? What's our bottom line number? What are we really arguing over?
Yeah. Yeah. And the great thing is that a mediator is so neutral. The realtor can provide all that information, but the mediator can like literally talk through the scenario, and it might cut through all of the, of the emotion. I don't know. So anyway,
I, I
Jay,
always think the mediator's agenda is to be able to check that box that they successfully mediated a solution.
yeah, exactly.
That's the emotional reward for the mediator. Am I wrong, Alice?
That is absolutely correct.
Okay, Jay, I'm ready for this case study. It's really interesting.
Okay, so this is a case study for a case I had about a year ago. This is a 2-page slide, and I'm bringing it up to really talk about how sideways things can go when you don't plan. So a lot of my families have houses where they bought the house in the 60s, 70s, or 80s for $35,000 or so. Here it's $25,000, and now fast forward to 2020, and it's worth $1.25 million or more. In this case, the mother predeceased the father. There were 3 children. One of the children had developmental disabilities. And unfortunately, they're downwardly mobile. Father, back in the 70s, on a blue collar job, you could afford to buy a house in San Francisco Bay Area. Not so true anymore. So, they have jobs, but they can't go out and get a mortgage on new property. Father, towards the end of his life, had diabetes and heart disease and kidney disease, had several limbs amputated, and required very critical care, intensive critical care. So a niece sweeps in towards the very last days of his life, spirits him away to Santa Rosa so she could care for him, and he promptly dies within 2 weeks. And based off of the medical records we got in the case, it was from malnutrition and dehydration, right? But before he died, niece set up a new estate plan, naming her as the personal representative, the person in charge, and as the beneficiary of the plan. And then father died. And then she moved to evict the daughters from father's house in San Francisco. And she succeeded, right? Because they didn't have the wherewithal to go to the EDC, the Eviction Defense Collaborative, until it was way too late. They didn't understand their rights. They assumed that their cousin, the niece, had no right to inherit it. And they really didn't have the resources for an attorney at that point. So they were evicted. The niece took over the house, renovated it, and sold it, right? And now has the money. Now the children come to my office and say, hey, what can we do? Well, that's a great case for financial elder abuse. I take on the case. And our goal is just to invalidate the estate plan, because under the probate code, the 3 children should just inherit equally. And that, it's more expensive in the sense that there are going to be probate fees, but it's not as expensive as losing the entire house. So they're supposed to inherit. Now, as we go through the litigation, we discovered that 2 of the children actually weren't biological children. So the mom and dad had raised them as their own, had held them out to the community as their own, but had never made an attempt to legally adopt them. And there is a law called equitable adoption where you can, if you raise someone, treat them like your own child, and try to adopt them, but fail because maybe the birth parent doesn't agree or you can't get consent to it, then you can still claim for equitable adoption. But that's not what happened here. They never tried to adopt. So we were down to our last leg on the original daughter, only to discover during the course of events, to her surprise, she was not a daughter either. She had always been told she was, but the birth certificate was sealed, and she in fact had a different father. This is a fact known to dad and mom, but never told to daughter. So that's our case scenario, because it has parents, it has transfer, it has people with other agendas, it has real estate, it had opportunities for resolution throughout that. So what I thought I would do is go through this and talk about, with this case study, what did this look like without a plan, and what would this look like with a plan? So when you have, I got a quote up here from my favorite progressive rock band, Rush: "If you choose not to decide, you still made a choice." And that's, besides being philosophically profoundly true, it's also legalistically true. The probate code has a default estate plan in it for everybody, right? Who's going to be in charge of you if you become incapacitated? Who's going to be in charge of your estate? Who's going to inherit your estate? What kind of fees are going to be out there? If you have nominated guardians for children, who are going to be nominated guardians for them? And then solutions for when it goes sideways. So when you don't have a plan, you've opted into the court plan, the probate plan. So probate, just to be clear, probate is a court, part of the county superior court system, that decides what happens with incapacitated people, children who are minors, and what happens with your estate when you pass if you don't have a plan. Right, so that's the court we go to address these issues. Now, what should have happened in this case? 3 children and an incapacitated father, and he wasn't lightly incapacitated. This wasn't sort of 5 minutes before he died, he didn't quite know what was going on. I mean, this was heavy incapacity. At some point, they should have received guidance to go to court to file for conservatorship. That's when you petition the court for powers to take care of someone's assets and liabilities, and to take care of their physical person. That never happened. And because that never happened, that left the door wide open for the niece to swoop in there and take him, have him sign something she prepared, and then abuse him literally to death. So conservatorships are what we do when someone who's an adult is incapacitated, and someone needs to have legal power to manage their affairs. Now, we frequently think that grown children, adult children can make decisions for their parents, or parents can make decisions for their children, or brothers and sisters could step in if they needed to. And we assume that because that's how we informally handle things, but that is not how the law works. I can tell you, if you go to the bank for your mom, and you have no powers to withdraw from the money from the bank, they're not going to let you. If you go to the hospital and ask for medical information on someone who's there, and you don't have an advanced healthcare directive, legally they're prevented from telling you. So you should have a conservatorship in a worst case scenario. And when you pass, then if you have no plan, we're going through probate. Now, if you had come to me before COVID, I would have told you that the average probate in San Francisco would last between 12 to 18 months. Now I'm telling my clients 2 to 3 years, because you see, the probate court in San Francisco hears 3,000 petitions for conservatorship every year. There are only 2 judges in that department, and they're dealing with probates, and they're dealing with trust litigation, and they're dealing with a whole host of other things. So nothing happens quickly. Nothing happens quickly in the probate court. You can get an emergency conservatorship, and we might be able to set up a conservatorship in 90 days, but a probate, just to get someone appointed to be in charge of your estate, is going to take at least 7 weeks, and we could be there for years. I actually have a colleague who has another probate case, and I saw it when I was in a hearing, sitting in on a hearing, that's gone for decades.
Oh my God.
So probate is the process, in theory, where you gather, you get someone appointed in charge of the estate, the executor administrator. We gather and inventory their assets and identify their liabilities. We notify creditors and beneficiaries, and then, hopefully distribute the assets to the estate. And that sounds like it should be really easy, except when the family's fighting, that's really hard. Except when the family has no idea what the parent's assets were or the brother or sister's assets were. It's really hard. Something that's been made more complicated by technology, right? It used to be we could sit by the mailbox and wait for bank statements to come in and retirement statements and whatnot. We knew what they had owned, but now it's all locked up in their email and we can't really do that. So we lose a lot of assets. And when we talk about the government and probate, we're really talking about me, the attorney, because I get paid a percentage of the value of that estate. It's like a real estate commission. You can Google California probate calculator, type in the fair market value of your assets, don't subtract mortgages, and it'll tell you what my starting fees would be. $1 million estate starts at $23,000 for the attorney. The personal representative gets paid the same thing, and it can go up from there. So we also have creditor claims. Now, the good thing about death, if there's a good thing, is that it acts like a bankruptcy. 1 year after you die, except for secured creditors and government creditors, creditors are barred from collecting on debts. So if you owed your cousin $10,000, you died 1 year later, he came and sued the estate, court would say you get nothing. But it also means creditors can be put in charge of your probate estate if nobody else applies, right? So that's a stakeholder issue. Frequently, this will devolve down into litigation. You saw in that case model there, right? We had me representing those daughters who were fighting the attorney for the cousin, and it was a knife fight in a phone booth trying to get to a resolution on that. You saw the eviction landlord-tenant litigation. Sometimes the litigation comes from when someone was killed and the estate needs to sue on a basis for wrongful death. I have that probate right now in another case where a boat full of scuba divers caught on fire last year in Southern California, and about 30 of them died. And so we're suing a lot of different companies to recover value for the estate. And you see in that case, the elder abuse, right? So if you, a caregiver, take possession of somebody, have them write and sign an estate plan naming you as the beneficiary, that's what we call elder abuse. And in my opinion, in the Bay Area, you can't walk a block in any given city where there's not some level of high level or low level financial elder abuse happening. Now, there is the case for also physical elder abuse, right?
Wow.
He starved, he died. But this is what you sign up for when you don't make a plan. And this is why it's important to communicate, to get mediators in there, to get opinions from real estate agents about what the assets are and what we should do to shelter them from this sort of chaos. Because I can tell you while this fact pattern is an extreme fact pattern, it's not an unusual fact pattern. That is, an interested family member tells everybody that he or she's going to take care of everything. Don't worry about mom or dad. And then after mom or dad die, it turns out that person's getting everything and they have full control of all the bank accounts. And now the family members who have a right in that estate have no resources to litigate over that estate. And the bad actor is in full possession of a very, very deep treasure box of resources to protect and keep what they've stolen. Perhaps our most famous estate litigation case that's been in the news recently is the litigation Donald Trump did to basically do this in his estate, if you believe Mary Trump, to seize control of it, take advantage of it, and for his own benefit. So it puts a little color on the actuality of this, but this is a very day-to-day occurrence, especially around real estate.
Yeah.
So,
Yeah. It's the other thing I wanted to jump in around timing that I didn't might be, and I'll let Alice take over the next slide, is when it, for the financial planners on the call, when the family inherits buildings, property, whatever, you do have a timeline in terms of filing to the IRS, and you will incur fines if you don't help, if you're helping that family financially stay on the timeline. I think that's really important to know. But really, yeah. So what, like I said from the beginning, there's a lot to unravel in terms of inheritance. So I'll let Alice take it over with mediation.
So I just wanted to go over what mediation actually looks like for those of you who have never actually been through a mediation. I mentioned earlier that everyone has to agree to that. That is not necessarily an easy task. I've had several that actually did not move into mediation because one side refused to mediate, right? They want to litigate it, or they don't want to sit down and talk. Or there was one that was like very egregious in that one sister said, I don't trust her at all. I believe that she's going to manipulate everything. I believe she's going to try to get what she wants in the mediation. And because I don't trust her, I'm just going to stick with an attorney, right? And so that itself can be an enormous task if there are parties who are not willing to go to mediation. And then not only do they have to agree to go to mediation, once everyone agrees, then you have to agree on who the mediator is, right? So that's yet another thing. So, and typically what attorneys do is that one side will offer three mediators that they're okay with, and the other side will choose one of the three. So if you're trying to do this with your family, and trying to figure out the best way to get people on board with the same person, you can use that same style of negotiating where you offer multiple people as possibilities. You're okay with any of them, and you allow the other person to choose the one. Okay, so that's a really good strategy to use. It sort of cuts down on the conflict. Mediation only, the mediator, I act neutral. So I'm never advocating for one side or the other. A lot of what I do is I try to keep people calm. In your brain and everyone's brains, when your emotions go up, the logical and reasoning side goes down. It's kind of like a seesaw. And so when your logic and reasoning side is up, then your emotional side is down. So a very large portion of my job, particularly in these highly emotional stakes game, as well as, ones where there's like 30 to 50 years of contention going on, people will not be able to get through a conversation if you as the mediator cannot keep them calm. Right? Because once they start to get riled up, once they start to get emotional, the conversation is going to dead end. And so in order to be an effective mediator, you have to know strategies that work with all parties to keep them calm. That could mean something as simple as calling a break when a break is necessary. That could mean putting people in separate rooms, even if it's temporarily. One, it could be just so that they can just cool off, or two, it could be so that the mediator can just go and chat with them and kind of get them to a place where they're back thinking reasonably again. And then you can, or you don't have to go back into the same room to continue talking. Most of the time it's better to go back together, particularly in cases where there's family, because they're going to have a future relationship with each other. So once they calm down, then to be able to bring them back in. I also prevent them from interrupting each other. So interrupting people leads to yelling, because the person who's being interrupted starts to raise their voice. And then when that person is raising their voice, and the person who's interrupting also has a tendency to raise their voice. So now you have two people screaming at each other and no one is listening. And so I prevent all interruptions from happening. And another tool that I use is called mirroring. And so what I will ask, let's say I'm meeting between Jay and Darcy, I will basically tell Jay, all right, Jay, once Darcy is finished talking about what she wants to say, I'm going to ask that you repeat whatever it is that you understood. And by asking Jay to do that, he's going to be using his logic and reasonable side of his brain, and he will not be able to get angry as he normally would, because he's engaging in the other side of his brain. The two of them cannot be functioning at high levels simultaneously. So by employing that tool, Jay thinks, oh, well, all she's asking me to do is, tell her what Darcy is saying. What he doesn't realize is that I'm also preventing his emotional side from getting too flared up. So I will ask several questions and allow everyone gets a chance to say what they want to say. Everyone has a chance to respond to what's going on. So one of the things that I let people know in the very, very beginning is to say, look, you will each have your chance to say what is you want, and you will each have your chance to respond. So when people feel comfortable knowing that they will be heard regardless, they're much more likely to not interrupt and feel frustrated, because they know that I'm going to hold space for them to be able to at least refute, respond, and speak their whole truth, right? So, and then basically at the end of all of that, if I do my job well, then they end up with an agreement. The agreement might be something that everyone's happy with, because I try to make win-win agreements, but sometimes it can be the type of agreement where everyone is slightly irritated about it, but you at least get there, right? So a lot of mediators will say, a really good agreement is one where everyone is slightly dissatisfied about it. So yes, that may be true. And I also like to think that there are win-win solutions that other people have not thought of, and I try to come up with it. It happens even when there are lawyers on both sides. In my opinion, it's the lawyer's job to look at everything microscopically, and you cannot look at everything microscopically and look at it from a telescope simultaneously. So my job coming in as a third-party neutral is to look at everything from the 10,000 level above, while the lawyers are looking at it microscopically to make sure there aren't any holes in it or anything that will go wrong in the future. And then I can throw out problem-solving ideas that no one else has thought of, because I'm coming at it from a completely different, not just neutral perspective, but from a very high level perspective. And I also look at everyone's interests. And I sometimes, these things come to me where I say, okay, well, you want red and you want blue, but like purple has all the colors in it. And people say, oh, I didn't even think about, choosing purple, because they're so busy fighting over red and blue. So that's another benefit for using a mediator.
Now, Alice, one of the things I seem to observe that I'd like to hear what you have to say about it is, there's what appears to be the objective interest of a party at mediation versus the real motive. What's really driving them there. How often do you see that the starting point for why the person is staking their position really isn't at the end of the day what the dispute is about?
Most of the time. And that's sort of when I say my theater background and training comes into play, because as an actress, when you're training, you're always trained to look for the other character's motivation. What is their underlying subtext? That's the word that we use in the theater, the subtext. And so we're constantly trying to read the subtext. So as a mediator, I'm doing the same thing. I'm trying to understand what is driving them, not the words that they're saying, not the position that they're taking, but why are they where they are, and why are they demanding that? And so I look for a lot of clues as to why that might be. And I ask a lot of questions to uncover the actual reason. So instead of saying like, Jay, why do you feel that way? I don't necessarily ask those questions. I might say like, Jay, what are some of the things that make you afraid if Darcy were to take the house and live there? What are some of the concerns? And then you will raise those concerns. I might say, Jay, what are the concerns that you have if your other sibling, they want to sell the house? What are those concerns? And then you may say it. And in the meantime, you're going to be like talking all about how Darcy and your other sibling, like, I don't know, threw rocks at you when you're 5 years old, and then your mom didn't do anything about it. And all those things come up. And I always allow for each of those past scenarios to come up one time so that they feel heard. And I don't let it come up after that. After that, I'll say, okay, so we understand, we heard, and I'll repeat what it is that I heard. And I'll say, however, it's not helping us to move to a resolution. So we need to focus on the future. And so we need to go from there. So that's actually how I keep people from spiraling, particularly family members, from spiraling into the past. And I also explain to them, everyone has their own perspective on what happened, and we're never going to get to an agreement on what that perspective is. So now that I've heard you express your perspective, we need to move forward with like the actual resolution. So that's sort of how I drive it forward. And yes, most of the time it's something else.
Yeah, I think part of the problem, the breakdown in solving it before it gets to the mediator in a litigation context, is we're just fundamentally wrong about what the motive is. And so you can't bring the right tools to the problem if you don't understand really what it is. Now, in my experience also is when parties are selecting a mediators, and Alice, I don't know if you do this, but can the different call beforehand before they select one just to talk to you about what mediating with you is like?
Yes, they can. They can always call me and talk to me. I give a free 30-minute consultation. And so during that time, they ask whatever questions they have of how the mediation process works. How do I handle conflict? What are the different ways that I deal with the people in the mediation? And so if you are looking for a mediator, definitely call around, interview multiple people, and find out, who you like the best. And the way you want to figure out who to use is you want to make sure that you trust that person. Right? Inherently, everyone needs to trust that person. That person should be working for everyone and advocating for no one. Right? And so you want to ask things like, how do you deal with conflict? How do you deal with difficult people? When people interrupt a lot or they're yelling a lot, what are some of the strategies that you employ in order to get through high conflict situations? And ask questions like that to find out if they will be a suitable mediator.
Yeah, I think that's good general advice. I always tell people whether you're hiring a lawyer or a mediator, question is, do they have the skills to do the job? Are they trustworthy? And do you like them? Those are the sort of the three things in any interview, whether it's for a job or a marital partner or a mediator. Those are three good things to look for, so you have to build that rapport before you walk in the room, hopefully, if possible.
Yeah. Great. Thank you. Um, really quickly, what I loved about what you just said, Alice and Jay, is that you're really in moving to a resolution. I think the thing about a real estate property is when you start talking about real life numbers, it is what it is, right? You can present comps on, what you inherited, and that's what sold, and that's where the market is. You only know what a buyer's buying, what buyers are buying in that neighborhood by what is just sold. But I wanted to say, and I hadn't thought about this until this conversation, and I'm inspired, to be honest with you, with both of you, is that when you have three siblings and one just doesn't have the money, and the other two own houses, and that money is just going to be part of their wealth or their portfolio, and one other sibling is, falling on hard times or just, hasn't really made much money. Their perspective about that house and their attachment to living there is going to be coming from a whole different set of, what's going on for them. But there might be another way of approaching this, is to say, look, if everyone wants to sell, you're getting money. Let's look to, to house you in the right environment and create a solution for that sibling as well. And I thought I'd put that out there just because you may be on the call and may be in the situation with one of your siblings, and there may be a win-win for your sibling too with selling the house. But what I wanted to talk about in this slide is assessing your house ROI. We talked about that. The market changes, the rental market changes. Like right now, we're in COVID. The rental market for one bedrooms has pretty much gone down in value. They have tanked. And the market for selling one bedrooms had tanked quite a bit over the summer. They're coming back right now. And the reason for that is most people need more space. They're doing everything under one roof. So what happens when, you're in mediation and, the people who want to keep the house because it's emotional and they are going to let the one sibling live there, they have to understand rent control. Because the minute that sibling or whoever they let move there, like say it's a 2-unit, and now they're going to rent out the top unit, they have moved people in, and they are that amount that they agreed to take for rent, that's where the buck stops. It's only maybe a 10% increase each year, if that. And the laws are changing, and we're coming up to election, and there's going to be a lot of laws on how the taxation of buildings on this, on the different props. So I think it's important that in engaging a realtor that you ask the right questions. And if some siblings want to know about rent, then you should ask the realtor to provide rental comps as well as the sales comps in the neighborhood. Also, you should ask the realtor to provide exactly what happens with rent control. We talked about transferring that. Okay, so the other part I wanted to just quickly talk about, this conversation we've had has mostly been towards a medium price home, single family. But what happens when your family members own commercial property? What happens when it's a 5-unit and above building? Those are very different taxation laws. And that means that there's possibly, you are inheriting tenants. And in order to sell a building, you have to sell a building with the tenants or buy the tenants out. And I am saying that because I've done sales. I have a lot of developers who love apartment buildings, and it's called upon, with the close, we deliver the building vacant. And that's not always easy to achieve. So those are different conversations that you're going to have if the inheritance includes apartment buildings. 1 unit to 4 units is still considered and taxed like a single family home. Anything above 4 units is in a whole different bracket of taxation. Just wanted to let you know. So different things to think about when it comes to what you're inheriting and how you're valuing your return on investment if you decide to sell, and what you decide to do with it. This is not pretty much is repetitive. Rental laws affect long and short-term family goals. This is the one thing I say to anyone that calls me, and I say it to people who are inheriting property. I think if you can get everyone on the same page, I don't know if it's possible to decide short-term and long-term goals. And you ask yourself, you're maybe one of 3 siblings. What are my long and short-term goals? And how does going to my mediator with my siblings fit into, how's that part of the conversation? Because in my mind, every person who calls me, whether it's a seller or a buyer, the first question out of my second question, first say, do you have another realtor? Because I don't want to step on anyone's toes. But the second question is, what are your long-term and short-term goals? Because that's going to drive my approach to assisting them.
Okay, so now, one thing I've talked about is what happens if you have no plan. And if you look at this chart, you really get a good sense of our 3 options, and generally speaking, on estate planning. What happens if you have no plan? Well, that first column says the person who's going to be in charge of your estate is decided by the law, meaning we go to court. Guardians, we go to court. Who gets your assets? We go to court. When do the beneficiaries get the assets? We go to court. Are we going to be subject to probate and Medi-Cal recovery fees? So just a pro tip here, if you own a house and you pass it on to your children when you die, it's not in a trust, and Medi-Cal paid money for your health care after the age of 65, they can come to your estate and claim reimbursement for all the money they've advanced for you, right? So if you're in an elder care facility and they were paying, I don't know, $100,000 a year for 2 or 3 years, they can come back to your estate and claim that $300,000. It's a big problem. So what happens if you go to a will? Well, you decide who's in charge of your estate. You can nominate guardians for children. You can pick who will get your assets, but you're still going to court and going through that probate process and paying those probate fees to solve the rest of that estate. So when we're looking at tools that really effectively address a family that has wealth, essentially has wealth to transfer, that's at least in the 6-figure range, we need to look at different tools. And the trust here is, as you can see, substantially empowers a family and reduces interference from third parties, and reduces costs frequently, and increases control. And that's one of our tools. Now, the first tool here is conversations, right? Is when you come into my office or call me up for consultation, we learn about your family and we talk about your assets and we identify issues within the family. Is there a child who's a special needs child? Do they need a special needs trust? Are they going to be in a condition either because of developmental disability or accident or addiction where they can never take control of that value that is your inheritance to them? If so, we can set up a trust for that. What do we do to make sure you're okay? Well, there's an advanced healthcare directive and a durable power of attorney for you, so that if you become incapacitated, we have a few people who can step up and take control and make sure that you're as comfortable and well provided for as possible for the rest of your life. If we want to avoid all those probate fees, we're going to go into a standard, what's called a revocable living trust. A married couple will set up a trust, transfer their assets by and large, with the exception of some tax deferred assets like IRAs and 401ks, into their trust. It'll be managed for their benefit while they're alive. They'll do the managing. And then when they pass, it goes to their beneficiaries on the conditions and terms they decide. So if you are one of those families who rewards efforts, you could say, well, my daughter who was there and took me to all my appointments and housed me and all these sorts of things at the end of my life, maybe she gets a little bit more. Or if you're one of those people who says, I go with an objective standard of fare, we're going to split an estate 3 ways between my 3 children, you can put that in there. Or you can look at success issues. My child who is fabulously wealthy due to the IPO, really doesn't need anything. And my other child, who's a social worker doing great, work in the world, but maybe undercompensated for it, needs a little bit more. So it gives you a lot more nuance and control over who gets what and under what conditions. So that's how we take control. But that's all around conversations, the conversations you have with your attorney to really understand the value of the assets. We need to get valuation. So I have an estate right now where my client owns 6 different properties. Some are residential, some are commercial, some are hybrid. And we need to go out to realtors and get opinions, or appraisers and get opinions on what the value of those properties are, so we can properly plan for tax consequences, estate tax consequences if they apply, capital gains, income tax, property tax, all these different issues. And that's how we can effectively create the plan. And where there are issues, either because of health or interpersonal dynamics, maybe there's the kid who's a little more problematic than the other, we need to get some mediation in there. We need to get the stakeholders to the table to see if we can work out a plan beforehand that people can live with after parents pass. My ideal time for mediating a thorny issue is before anything important has happened, right? Because maybe it's a few $1,000s to take care of it now, but compared to creating a family-wide divorce when the litigation breaks out after mom and dad have passed, is money well spent. I mean, we all know when we were in 3rd grade and the teacher left the classroom, we all know what happened in the classroom, right? Once the responsible adult was out of the room, it did not stay calm and quiet. I wish that changed when we got older, but really it doesn't. We're just kids in older people's bodies when it comes to how we deal with our families. So I tell my parents, make the hard choices. Make the hard choices now, because it's better that that troublemaking daughter resent you than that she resent her brothers and sisters. This is a gift. This is a step up. This is an opportunity to improve the quality of life for the people you love. It's not intended to be a trap to destroy the quality of life for the people you love. And where you've got stakeholders that are really problematic, there are extra steps you can take, right? If you don't have a family member who can be trusted with the estate, then maybe it's time to call a professional fiduciary to be appointed as trustee and executor and personal representative. Or maybe you need to put a disinheritance clause in your estate plan and say, hey, we specifically thought about this person and decided not to provide for them for whatever reason you want estate. Or maybe you need to put some litigation controls into that estate plan that says, hey, this is what everyone inherits unless someone sues over it, in which case they get nothing, right? That's a big motive, because now you're saying, well, if I lose what's called a no contest claim, trying to grab more out of mom and dad's estate, instead of getting 1/3 of it, I'm now getting 0 plus my lawyer's bills, right? That's a persuasive argument to make in the estate plan. And where there are issues of elder abuse, where you're concerned that we've got a good plan set up for mom or dad, but we're afraid that they're 90 and the cousin or the neighbor or the other kid's going to come in there and swoop in, we have the opportunity to put protections in there that say this plan can only be modified or revoked if approved by a 3rd party. And you can pick the 3rd party. Maybe it's another family member, maybe it's a lawyer, maybe it's some other trusted advisor. But we can make it hard for people to commit abuse and to make sure that your plan goes off as you want. So we've got now a scenario with what happens when you have no plan, that very nasty case scenario I threw out there, which isn't sadly all that unusual. Or when you have a basic plan, powers of attorney, a will, a trust, or if you have an enhanced plan where you have those documents we talked about and you build in nuanced controls in it. But you can only get to those when you really talk effectively with the other advisors, the real estate agent, the mediator, the attorney, to really figure out how to make that happen. And so my goal in this presentation, sort of said after the fact, is that you understand who the stakeholders are, what their agendas are, what happens if you don't plan for it, and tools for planning and guaranteeing that success to the extent you can, because you only have control over what you have control over. And as Darcy said, if you were planning the finances of your estate based off of the rental income of a 1-bedroom apartment in a tower in San Francisco last November, that plan's gone sideways, And we can't control for that, but we can control for a lot of other things.
So we're going to open this up to questions. We kind of, our thought was, educate you so that you can, plan now before, you get into the position of someone dying, know your options, estate plans versus wills, trusts, family mediation, which is always available. And you don't even have to have a problem. You could call Alice if you and your siblings are just can't decide, what to do about something big around, the current situation we're living in with COVID. You don't have to wait for an estate plan to go to mediation. And then, of course, real estate assessment. It's always good to know, what's in your portfolio. Any questions?
Well, if I could just point one thing in there, Darcy, with mediation, I think people tend to think of mediation as where you go to when you already hate the other person, right? You can be at a point where you like the other people, your other family members, but you guys can't solve this problem.
Yeah.
And you need help solving that problem. And so I think that's a great place to go in before dysfunction has set in.
Yeah.
Absolutely. Jenny, who had to hop off, had a question. She put it in the chat about if there's a joint tenancy with a father and a son, and the father passes away. Her question was if the son will still get the father's half, even out of a trust.
So joint tenancy in essence is a way of putting a little will on a deed. It says this person standing owns the house, right? So I had a case a while back where there were 4 joint tenants on a deed. And one, they all died till it got to the final person's mother who died. And by intestacy, that daughter inherited. Now, they weren't all brothers and sisters. So all the cousins were pretty mad about that, right? So that was a very good way to avoid probate, in the sense that joint tenancies aren't subject to that probate process we discussed earlier. But a terrible way to make sure the people you love are protected, because the families who lost out because of that joint tenancy deed, their children got nothing, and my client got everything. And the first thing I did is run down to the recorder's office and record affidavits of death of joint tenant for all of those people who had died, because that put us in a substantially stronger position of leverage.
Okay, can you talk about that? We talked about this a little bit about reconveying and changing the name on the deed.
The deed, yeah. So normally, if a client comes in with a joint tenancy deed, and typically these are very common in the 80s and 70s to say, husband and wife as joint tenants. That says 2 different things on it. It says, first, when I die, everything goes to my spouse. However, it only provided a half step up in basis for capital gains tax on the death of the first spouse. So typically that's a bad way to hold a deed. Community property is a better way. Husband and wife is community property because they get a full step up in capital gains tax basis on the death of the first spouse. Now, so if a client comes into me and says, hey, I want to set up a trust, I've got a deed in joint tenancy, what do? Well, I'm going to prepare 2 deeds. The first deed is going to sever that joint tenancy. It's going to change it from husband and wife as joint tenants to husband and wife as community property. Why? Because we want to memorialize that step up in basis for capital gains tax. And also we want to abolish that right to inherit on the death of the first spouse, because the next thing we're going to do is what's called a trust transfer deed, where we now transfer it from husband and wife as community property to husband and wife as trustees of their trust, and we record that. And so the deed, when it's transferred into the trust, inherits that community property tax benefit, while also getting the trust protection benefits from Medi-Cal recovery, managing assets for children until they're old enough to inherit them, protecting them from probate court protection. So it's very easy to revise a deed. I do it all the time for clients. It's very easy for me to do it, right? I do it, but I remember the first time I ever did one, I probably stared at the thing for 3 hours before I figured it out. But it's very easy to change a deed. What you don't ever want to do, though, is put someone else on the deed with you. Now, Darcy, I'm sure you've seen this, where mom puts, son-in-law on the deed so they can mortgage qualify.
Yes.
And never takes them back off. Son-in-law and daughter divorced, but son still has now an interest in that house based off of what that deed language is. And so you've set up litigation. If son runs over someone and there's a wrongful death claim against him, mom's house is now on the hook for it. So don't ever, 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 ever put someone else on your deed. Instead, transfer it into the trust and say who should inherit in the trust, who gets the house from the trust.
Nice. Any questions? Well, I have a little case study on, I have a client right now who's very, very wealthy. And I told Alice and Jadis when we were preparing for this talk, this gal is 70 or 80 years old. She's a Spitfire. She left her $3 million pied-a-terre to go live in her other house in San Mateo during COVID. I talk to her regularly. She's not a client yet, but she's been dancing around this concept of buying at the new Four Seasons. And because she has no family members, both of her kids died and her husband died. So she is the only survivor of many, many apartment buildings, and she has quite a bit of wealth. She wants to be in this relationship with this guy in Chicago. So in order to sweeten the deal and entice him into coming out here and being boyfriend and girlfriend, she buys the $3 million condo at the St. Regis and tells him she's going to put his name on it. If anything should happen to him, he gets the condo. Okay, fast forward 6 years later, she's like, you know what, and we've been talking, I think I will buy at the Four Seasons. And then she doesn't want to really disclose this much, but we're on a talk about how the move would go, because St. Regis is only one block from the new Four Seasons and it's not done yet. So she's not ready until it's fully done and she can see the units. And I'm like, well, what do you want to do with St. Regis condo? And she's like, oh, you're never going to believe it. You're never going to believe it, Darcy. Okay. You know, that guy is my boyfriend in Chicago. Yeah. Okay. He's on the deed. I go, can you call him? I tried because I told him I'm going to buy in the new St. He doesn't want to sign to let me sell. Okay. Here is the moment. Okay. That property in the St. Regis, 5-star residential is going nowhere because he's on the deed and he does not want to let that go. So she needs depreciation. So she's not falling apart over it and she still can buy, but it was a big quiet moment between us when she told me that. Let me just say that much. And there's just a little, she's not in most people's league of, finances, but still she's stuck now, right? This guy's in Chicago. She has to keep up the whole place. And she can't really sell it without him signing off on that deed. I just think that's a really interesting little story. But anyway.
And I see that way too often I see where someone has been put on a deed and all altruistic at the time, but it's not reversible without consent. So it's better to put it in a trust where you can change it at will and provide for the future, but not compromise yourself in the short term.
Right. Alice, you want to wrap it up?
Sure. Thank you very much for attending. This is the contact information for each of us if you'd like more advice or the services of either Darcy, Jay, or me. And I want to thank you for coming today. And I hope this was a very informative talk for those of you who work with clients who maybe deal with inheritance and that sort of thing, and as well as for yourself. So I appreciate your afternoon time and thanks so much.
Yeah, thank you.
Thank you, everybody.
And if you would like the slide deck, please reach out to me. And if you would like the recording, please reach out to me. We may want to offer this again, but we will definitely send it to you.
Thank you. And thanks,
Great.
Jay. Thanks, Darcy.
Thanks, Darcy. Thanks, Alice.
Yeah,
thanks
guys. Fantastic. I really loved it. It was so much fun.